doing his best Jeff Manny impersonation. Here we again have Thibault Schrepel, who, much to his credit, has been the only moderator to end on time today. Let's see if you can stay in my good graces, friend. With that, Thibault, please.
Yes, thank you very much. That's why I got promoted, and all of the others, moderators, will be denied champagne. Now, the good news for me is that none of the speakers, I'm told, had access to the notes that Jeff sent me. Now, I also discovered that Jeff is actually a wizard because, and I promise you this is true, he already drafted in the morning, or I guess in the days prior to the conference, things such as, earlier today we've heard this and that, what's your reaction? And you know what, he's actually kind of right, but some of the things we haven't heard. We haven't heard about speculative theories of harm in merger control, but we'll try our best to deliver on those. My objective with this very last panel of the day is to make all of the speakers out of breath when they leave the panel, because I want it to be as dynamic as possible, which was also one of the underlying themes of the conference. So, and this is why we come to the bad news, I'm going to give you each 3 minutes to answer the questions that I have for you, knowing that I will come back and forth, so you'll be asked a couple of questions. But let's try to avoid the 15, 20-minute kind of presentation so that people are indeed kind of in a state of awareness and can resist the urge to go to the champagne reception. Now, to start with, and it will be impossible for me just to make it clear to keep track of who's speaking, so I will, for now, do it following the order in which you are sitting. Oh, I asked, yes, I mean, that beautiful jacket had to be on the panel. It was made not in Europe. This is how chic Philippe is. All right, I will ask you the very same question, so please keep in mind that I want you, for now at least, to keep it very short. What is the most compelling lesson that you've heard today, or maybe the idea that made you think the most? So I'll start with you, Marc, and then we'll go to you, Herb, and we'll follow that order for now.
Why me?
Because you are my preferred victim.
Well, it's a lot of things, in fact. So,
can you say I pass?
I don't know.
You can if you want. Yeah.
Sorry?
You can give me a pass.
No, well, I can. It's difficult to say. Well, I think that I'm an academic, so the fact that some question can be a source of research, this of course interests me. So I think that the discussion with Brian and Oliver was very interesting, because I realized that after so many years on contract theory, there are still a lot of things to do. And I think that especially what is missing is the empirical part of that. And how we should, what is needed to take into account what's the main lessons we can draw from this theory area that can be used to interpret data and to improve a process of doing policy.
Okay, so if I understand correctly, you are triggered as to which kind of empirical research I can actually put out in the next coming years, based on our theoretical discussions. All right.
Yeah, of course. I want to come back.
Of course. I mean, Jeff mentioned in an email this morning, maybe in Rome in coming years. I don't know. Okay, well, let's see about that. Herb, we go to you.
Which is again. Read the question.
So the question is, what is amongst like all the discussions we had today, the insight, if you had to select just one, that made you think the most?
I I think it was a matter of omission, and that is for a conference that's focused on substance versus slogans, we really didn't spend that much time on actual metrics. We didn't talk very much about market power and how it should be measured. We didn't talk very much about the differences between the metrics of merger control and cartel enforcement. We didn't talk about market definition. So, we really haven't done the metrics yet. We've talked about how important they are, but we need another conference to actually get into doing a few metrics.
That's fair. All right. Thanks very much. Philip.
So for those of you who stopped listening to me when I used the F word earlier today and mentioned fairness, a couple of things. One, completely agree. Don't pollute antitrust itself with other considerations. Number two, the consumer welfare standard is obviously helpful, but less so in European antitrust, as we've heard, and near irrelevant in the Digital Markets Act. So I look forward to conferences where something that is relevant to the Digital Markets Act from an economic point of view is addressed, a little bit of spike there. And thirdly, what matters now is implementation. As I say, the train's left the station. We in the UK have an efficiency defense. There's a massive role there. And I think indeed, because the UK is going to be focused on a market investigation reference framework, it allows a multifaceted and less intrusive remedial aspect than it does litigation in court, breakup, no breakup, end of. So that's what I would promote. And again, as we've heard already, the UK system has a very flexible remedial system of remedies and analysis, very quick impact assessment and ability to tweak and release remedies, which are really important, and tighten them. So all I'll say is, antitrust law and economics is fascinating. I'll always be interested, but we're in the room of regulation now, and there's a totally different set of priors. So let's remember that.
Thanks very much. Gustavo.
Well, my impression here then was really impressive how provocative, rebellious, and innovative is to say things that were well established in economical theory since the 70s. So it's after the last, I would say, 4 years, coming back to something that would be the basics, it should be the basics, and just saying, look, can we measure the effects? Can we measure how is it affecting the market? Can you actually care about consumers? It seems provocative at this point, and it's refreshing to see that there are people that still think like that.
So what I hear so far is that if we can come up with good measures, this would be good enough to actually overtake the slogans, right? Which maybe we'll come back to that, because I think there is a lot to be discussed.
Okay,
Andy.
I'll use this one. I think all the sessions are very illuminating and insightful, but I think the session on consumer welfare provide the food for thought for my further consideration, because that is an issue that I've been thinking about for quite a period of time. Recently in the United States, they focus on using the competitive process as the goal for antitrust law, but for me, competitive process is kind of abstract idea. And consumers' welfare is a test sort of to crystallizing or serve as a test to examine whether the competitive process has been restrained. Without this objective standard, something like be it consumer welfare or total welfare, competitive process is only a very concept in the air. After all, I think the Hayek has mentioned that the competition is the process of discovery. So competition is a process itself. So without any kind of objective test, competitive process will be kind of probably will be operationalized into something like if you want to get on the bus, you will be guaranteed a seat. But for me, competitive process should be refers to if you got a ticket, you won't be thrown out from the bus. So I think that's a very different idea about what competitive process is. And I totally agree with Fred's comment. In order to determine what kind of test we have, you need to be very sure about the goal of the antitrust law. I think that's something Taiwan need to elaborate upon further, because we are not very clear about what the purpose, what the goals our Fair Trade Act is. Because in the Article 1 of our trade, we mentioned several things: consumers' interest, fair competition, maintaining a just market competition order. So people really don't have a very clear idea what kind of ultimate goal the enforcement of the FTC Act is pursuing. So I think from the session, I think the Taiwan Fair Trade Commission really need to elaborate more on this topic in the future.
Yeah, so somehow we managed to put you closer to what the Court of Justice is saying, and I'm here going to quote Telea-Sonera, the case from 2011. It says that we should, when it comes to Article 102, consider damage to consumers directly, or there is an indirect way of doing it, which is to have a look at whether the practice was detrimental through an impact on competition or the competitive process. So good to see that the EU still has a very strong Brussels effect, because I'm told we have to be proud of that and not ashamed of it. Richard.
Well, I assume that I should not include my own presentation in the list of things that enervate me. I was intrigued by the list of companies that Paul Seabright put up. I've seen it before in the Draghi report, and it always makes me think, how much of this is due to antitrust policy? And I suspect antitrust policy is, kind of second order. I think it's more capital markets, this issue of labor mobility and the costs of terminating unsuccessful efforts. The problem is that if you want to be an innovator today, you want to go where you're going to make a lot of money. And you're probably going to make a lot of money. The exact same company or startup company listed on the NASDAQ versus the UK stock exchange, it's probably going to be worth 3 times as much on the NASDAQ. And I'm sure people think that way, so let's do it in the US.
Yeah, so more doubt as to whether we are of any utility whatsoever. Good.
In our own way, we're important.
Okay, good. Thank you so much for saying that. Pinar.
I think probably one of the main insights I'm sort of leaving the conference with is how little we know about how much. There are so many things we're talking about, but we actually know so little about so many of them that in terms of the actual sort of evidence base, and especially on the empirical side, if you compare that with the type of actions that are being taken, I think there's still a huge gap that needs to be bridged. On the more positive side, I was sort of pleasantly surprised to see that in places like Brazil and Taiwan, there is an evidence-led approach to the issues that arise in digital markets, and not everyone is actually adopting DMA clones, although, overall, I think there are quite a lot of jurisdictions which are adopting DMA clones, but it's nice to see at least still in some sort of parts of that universe, there is still sort of a robust competition approach to some of the questions that will fall within the scope of these versions of DMAs. And then maybe the last one is that one man's slogan is probably another man's substance, and I think that line between slogans and substance is probably a bit blurrier than we have been sort of making it look like today. And consumer welfare, I suppose, is actually one of those.
Yeah. Paul, I guess maybe for you, the question would be slightly different. Do you think that all of those speakers delivered on the promise that we made, that we asked the question and they gave us the answers?
Well, I thought slogans, not substance. Or no, it was a substance. What is the slogan?
More slogans, all right.
Well, I just undercut what I was about to say, because I was about to say it's a great slogan, but I was really waiting for the substance. And I can't even remember the slogan, so it can't have been that great a slogan, because the whole point about a slogan is that it sticks in your mind like a meme or like some Barry Manilow song. You just can't get out of there. And I felt that not enough of the slogans had this sticky property. Can I nevertheless answer the question I thought I was going to have to answer? Because I had 2 little things that I want to do very briefly, because I've been thinking about them since the people said them. One was what Oliver said earlier about how over the course of his intellectual development, he's become much more upbeat about what contracts can do. And in particular, contracts that are developed by the parties in a constructive spirit of an ongoing relationship. And he then said, well, yes, but of course, you still can't really bind human assets in the same way as you can bind, the other physical assets. And it occurred to me that, of course, one of the things he didn't talk about, and I'm sure it was at the back of his mind, was, I mean, correct me if I'm wrong, was that now so many digital algorithms can do things that previously we had to try and get contracts to do. So think about what Uber does. I mean, Uber restricts the kinds of things that the drivers can do. I used to get terrified when I was taking taxis back late at night from Toulouse airport to the center with these sort of, excitable, usually young male drivers who were driving very, very fast. And I knew that if I tried to say to them, could you go a little bit less fast, they would get really angry and drive even faster. And so now the Uber algorithm allows you to correct that very, very quickly. So I have much safer rides on Uber than I do on other things. So I kind of wanted to push Oliver a bit more on how much now can we do with algorithms that we used to try to do with contracts, and is that a good thing, and are there downsides of that? The second thing that made me think a lot, and it was only about 20 minutes ago when Julie Carlson from, excuse me, Julie, if I report a private conversation, said about 20 minutes ago that one of the challenges in doing R&D is that you'll often put together an R&D team for a specific context of innovation, and the world moves on and things change, and your team isn't as productive as it used to be. And in particular, it's not going to be more productive if you throw a lot more money at the problem. What you have to do is to reconfigure the team in some ways, and sometimes that means having an acquisition which brings a different team in with a different set of competencies that are complementary to the ones you had before. And I thought that was an important insight to share, because in very innovative companies, acquisitions are often about reconfiguring teams to meet new challenges. And I think when we're thinking about how we should use innovation as a backdrop to evaluating certain kinds of transactions, we want to think about trying to encourage companies to tell us to what extent are the acquisitions motivated by trying to improve the ability of the firm to meet new challenges by reconfiguring the competences of their existing R&D teams. Thank you, Julie.
Thanks very much. On the very first point, if you haven't read Exit, Voice, and Loyalty by Hirschman, that's a great book. And indeed, maybe algorithms create the ability to voice and or to exit when it was not here before. So that's another impact of technology, especially has big competitive dynamics and implications. Reiko, I go now to you.
Okay, thank you. Well, I learned a lot from great thinkers from around the world. Particularly, the Japanese Anti-Monopoly Act has properties similar to what Andy mentioned. We have words like fairness, fair markets in our law. And if you're an economist, you're always you're trying to make it into an economic concept, which we cannot do. And it was very encouraging to hear great economists and legal scholars here for tackling the same problem, and it helped me think through. I don't think a solution has been provided yet, but it was a wonderful opportunity to think about it even deeper. Thank you.
Thank you very much. Paco.
Okay, so, I'm going to reframe the question, if you allow me to. So it doesn't matter whatever I find more interesting, but what I find more scaring is I think the discussion about the consumer welfare has been there for ages. So I've been, listened, for example, Fred Jenny talk about this. I don't mean for decades, but for many years. But and also probably the discussion about innovation has been there also for a while. I think what I find more problematic, and the slogans which I find more, scaring, are the ones that have to do with the platform economy and digital competition. Definitely, we don't have there any of the metrics that you were asking for, Herbert or Pinar. I think it's great as a regulatory experiment. Some people say it's brutal. I learned that one of the things behind that is, I had a lot of talk about efficiency. No one cares about efficiency there. It has to do with fairness and contestability. Consumer welfare what I heard means that consumer welfare is not going to be there. We don't care about that. And plus, and it's important, we don't want to have the economists there because that probably provides politicians more room. And that's also probably good news for our lawyers. They're going to make a lot of money. So the DMA is great for lawyers. Thank you.
Bad cases make for good salaries. All right. I want now to try my best to follow what Jeff thought of doing, which is to divide the conversation in 5 different parts, where we try to come back to some of the main underlying ideas that we covered today. And the first one relates to the consumer welfare standard, so it's a very perfect bridge. And the first question will be for you, Herb. Given the fact that, as you explained, it did not change much because competition, at least in the US, antitrust was already about output, price, and innovation, and now we have a new term maybe for it, but it is still about that. Is it worth having the conversation about whether or not the consumer welfare standard is what we need? Or should we just forget about that slogan and focus on the actual objective of antitrust?
Well, I think it's arrogant to say we don't need to have the conversation anymore.
Yeah.
On the other hand, I'm getting very tired of it. I mean, it's been around so long, and very little has actually changed in terms of the basic standard that I think the best thing for policy to do is move on. I mean, I think that was a particularly harmful part of the Biden agencies. We had the 2010 merger guidelines, which stated as a, quote, unifying theme that mergers should be condemned when they facilitate the exercise of market power. Nice short statement, gives us something to focus on. And then the 2023 guidelines were just all over the place. They were a real step backwards in terms of finding usable metrics in that area. And right now, I would just like to get that buggy back on the track so we can start once again talk about areas where, you know, we've got a lot of work to do in things like assessing power, assessing mergers between imperfect competitors who frequently have very many complementary relationships. I mean, I was struck by that particularly this last year when I read the U.S. Air Spirit Airlines merger, in which the court was clearly blown away by the fact that there were many, many connecting routes between these two companies, and on those there were going to be significant consumer gains from facilitating easier transportation. However, 10% of the routes were overlapping. And under the single market rule and US merger law, if a merger is harmful in just one market, you have to condemn it. Those are things I think we still need to work through because the metrics of mergers are very, very difficult, and we just have not done a whole lot more than scratch the surface. And even good economists have emphasized that, how noisy and error-prone our assessments of mergers are.
Right. Marc, I believe you want to give a comment. I will do like in a presidential debate. I will give you 1 minute in case you want to answer one of the comments that is made.
No, it's to comment on Herbert.
Sorry, going on?
Was to comment what you are.
Exactly, yeah, please go ahead, but you have only 1 minute.
Okay, so, well, maybe it's boring to keep working on discussing whether it is a good standard, but I think, as you said, also we need a measure, and I think it's important to have it. And, well, I think it's also interesting to see how you can interpret the results. So we look at what is the optimal structure for mobile telecom industry. And so we did a model and we made a simulation. I talked about that to Frédéric before. And so it's on French case, so maybe it could be different. But the optimal structure for France, if we look at the consumer surplus, will be 7 firms. Okay? If we look at welfare, it's 4 firms. Okay? It turns out that we have 4 firms. Okay? So what does it mean is that, in fact, what we have just recovered is without the data, we have just recovered the decision of the regulator, because they have allocated spectrum to 4 firms. Okay? And at least we can interpret the result that we have like that. Which means that it is interesting because we then say that the regulator is saying, well, I cannot put all the weight on consumer. I need to give some rent to the firms because for some reason I want them to invest in the future, for example. So I think that we should not keep only one standard. What is important is first to measure to have this measure, and to make the effort of this measure, because that says something on what are the decisions, what is the functioning of the economy beyond.
So that's a question, a follow-up for you, Herb, that I have actually. There is a great paper, I don't know if you've seen it, published by John Mayo from Georgetown, in which he studied 7,000 mergers over the last 30 years and showed that actually it's incorrect to say that we have been more lax on mergers enforcement in the United States. When it comes to Section 1 and 2 of the Sherman Act, do you get a sense that indeed there is a good claim to be made that we've been over or under enforcing? Yeah. Is there any evidence, and what is your sense of that discussion?
I think merit control is good for lawyers.
Generalizing about that.
But already it tells a lot. The fact that you cannot obviously say it is clear that we've been over or under enforcing.
One place where we've clearly been under enforcing is in Sherman Section 1 rule of reason cases. And the reason is that we've placed a lopsided burden on the plaintiff. I mean, we have this verbal formulation. Phil Larita actually developed it 25 or so years ago, which the plaintiff has to show substantial market power and kind of a prima facie case of competitive harm. Then the burden shifts to the defendant to provide defenses and so on. And the formulation of the standard has not been where the problem is. The formulation, the problem lies in the fact that the Supreme Court doesn't really follow the standard. They make you prove the entire case before you can ever get the burden to shift to the defendant. And one consequence of that, and it's been pointed out many times, is that plaintiffs in the United States lose rule of reason, Sherman Act cases practically all of the time until you get to a case like the NCAA student compensation cases, which are virtually naked cartels. I mean, they're practically, the only reason they're in the rule of reason at all is because of some idiosyncratic definitions that the Supreme Court gave us earlier. And I believe there's one recent case that shows real promise here. That's the American Airlines joint venture case, in which the First Circuit from Boston applied the rule of reason, walked through the steps, and ended up condemning this joint venture between two major airlines. But overall, the record of rule of reason enforcement in the United States is, I believe, way too weak.
Yeah, okay. And maybe we need to combine your two insights in doing empirical work as to what has been the effect of those slogans on antitrust enforcement. I am told somewhere, a little voice is telling me that actually, Oliver, you do have a paper entitled Exit versus Choice that came out not so long ago. So a strong incentive for all of you in the room to have a look at this one. Let me now go back to you, Pinar. So what you said, it's not all of what you said, but including that the DMA is not flexible enough? Maybe. And in fact, we see that the effect may be not the ones that we anticipated. It may actually be that it allows the aggregators to generate more because it drives more traffic to them. We also have empirical studies showing that the DMA has actually been bad for Booking.com. Why is that? Because Google cannot self-preference Google hotels, and this was the #1 way by which people will go and directly book a hotel without doing it through Booking. So now, the DMA lacks flexibility. That's maybe a statement. If we then oppose that to competition law, we have more flexibility. And we've seen that in the cases against Google, where the European Commission was saying that, of course, prices are important, but maybe choice can also be used as a standard. And there is this idea that reducing choice is always bad for consumers, which maybe is a bit short-sighted. But is there anything we can learn from those cases in two-sided digital markets from the European side that could give us a hint as to, if we stick with the consumer welfare standard, a good roadmap as to how to make it flexible and improve it and make it workable?
You mean how to make the regulations flexible, or?
No, to make competition law flexible, because the DMA, it seems unlikely that it will become a flexible piece of regulation. So at least if we have competition law that has this potential of being flexible, my question is, can we learn from past cases as to how to make the best use of that flexibility of the consumer welfare standard?
Okay. Well, competition law is flexible. Competition law could apply and has been applied to pretty much everything that the DMA covers. So there's no question about the scope. I think the issue with competition law was that it took too long. But there can be a variety of reasons why it takes so long to run a competition case. So arguably one of them is because competition law involves the cases involve a lot of economic evidence, and economists have been exploiting this position. So this is the argument which was used partly to motivate why we need ex-ante regulations and why economics or economists shouldn't be involved in that new framework, because there's too much economic evidence being put forward in these cases. That's making the assessment very complicated, and that's why you end up with cases that take 10 years instead of 10 minutes under the DMA, let's say. But that could be one reason, but obviously that sort of forensic assessment of a case is also likely to lead to more accurate outcomes. So there's potentially that trade-off between reaching potentially a more accurate outcome versus reaching an outcome more quickly, but that may not be as accurate. But another reason why competition law cases may take that long, specifically, let's say in the EU, might be because of under-resourcing the judicial mechanisms. So there might be other ways of speeding up competition enforcement, which doesn't require you to abandon competition law, but none of those were considered. So if speed was, let's say, one of the main disadvantages of competition law, that could have been fixed in other ways, perhaps. In terms of, what we learned from the competition cases, I think the competition cases still also point out the importance of the empirical base. So in a competition case, you have the possibility, you have to deal with the evidence. Different jurisdictions now have obviously different ways of doing that. I think in the EU, it's more limited, let's say, in comparison to what goes on in the UK. But what we sort of learn from the competition cases is that these are all very different market circumstances, and they do require an assessment of the specific facts. And it's quite likely that if you have one rule that applies to a marketplace as well as a search engine, as well as a social media network, you're going to get a mixed bag of results. You may fix some problems, you may create new problems, and I think in terms of the accuracy of outcomes, the competition law approach is probably the
So if we look at, and I was struck to see that in the draft guidelines for Article 102, the European Commission is saying that they will update the legality test that it has been using in decisions. And when it comes to self-preferencing, the Commission itself lists that practice as one for which the legality test is not clearly defined. And in fact, indeed, we don't really know what's the legal analysis behind. So is it a way to say that the Commission is trying for competition law to be too flexible? Is there such a risk, in your view?
No, I mean, if you look at the provisions of competition laws in the US and the EU, and a lot of other jurisdictions have followed the EU model, I think they're like chewing gum. You can stretch them as much as you like. I mean, like I say, it's hard to think of a practice which won't be captured by one or the other of the competition law rules. In terms of self-preferencing, I avoid using that term because it doesn't exist. And I think that's perhaps one of the examples of the Brussels defect, that we have now actually created a term that doesn't exist in a dictionary called preferencing, which is now making its way into legislation in jurisdictions where English is supposed to be the first language. But that sort of tells us something. I mean, we don't need to make things up. What is called self-preferencing in the guidelines is discrimination. And that's more or less what the Court of Justice said. And we had discrimination as a potential abuse since decades ago anyway. So we don't actually need to make these things up. They are already captured by competition law under certain circumstances. And if you want to change the circumstances under which they're captured, that's a different motivation, and maybe that's the justification we're using a different tool. But competition law is already very flexible. I don't think, it's as flexible as it is. It'll be neither, too flexible or not flexible enough, irrespective of whether we make these new categories of conduct or not. I mean, you asked about consumer welfare earlier. I think in terms of, comparing competition law as opposed to maybe regulations, again, if consumer welfare, however we define it really, happens to be an objective we want to pursue, that will be easier to do also under competition law, because in these regulations, there is no real scope for that sort of assessment on an actual case. You would hope that at the principal level, these were taken into account. Whatever the objective was taken into account when drafting the rules, but when it comes to application, there's no assessment of that, at least in the framework you have in the EU. There might be more scope for that in the UK because of the possibility to include efficiencies and essentially objective justification.
Yeah, thanks a lot. Okay, so let's talk about that. So what we see in practice and our ability to operationalize some of the concepts we've been discussing, that's where I move on to the part 2 of our conversation about mergers, where the money is, so that should be exciting. The question I have for you, Richard, is the following. You've written on potential competition and the fact that it is often underappreciated in merger control. How would you approach the meta within merger in a better way, meaning giving more room to this concept of potential competition? Do you have a couple of thoughts on that?
If I recall the meta within merger, this was the merger of with the fitness app, where Within supplied some fitness app and associated workouts and that sort of thing. And that Meta was potentially interested in it from a perspective of their virtual reality headsets. I actually thought that the analysis that the court did in that case, I did read the case, was actually pretty good, and it focused on capabilities, which is which is certainly an ingredient in a dynamic analysis. The capabilities analysis in Meta Within was not very dynamic. It was more static, but it was still, on the borderline of, I would call, of a dynamic analysis. And the court reached the conclusion that Meta, with all of its hundreds of billions of dollars, didn't actually have the capabilities to develop a competitive fitness app because it was a very different business, and that therefore the acquisition was not a competitive problem. And it struck me as quite a sensible analysis that was pulling in issues that were, I would say, non-traditional issues in this kind of analysis, and did it quite well. The court did it well.
Regarding those non-traditional issues, you argued earlier today that the fact that disruption may come is irrelevant not to business players, but to antitrust analysis, especially in the context of practices being analyzed. You are saying that, however, potential competition or innovation could have a role to play. Is there any, in this huge galaxy of concepts and slogans, some other non-traditional concept that you think should be given some more weight in competition analysis?
Well, I do think when it comes to actual potential competition cases where you're dealing with someone who is an actual competitor, there is a concern, and Professor Hovenkamp has written extensively about this, and I'm not sure we entirely agree on this point. I agree with almost everything else that Herb says. And that is, that there are cases where you have an actual potential competitor, and it can be pretty reliably determined, particularly in the pharmaceutical area where you have these pipelines and you have projects that are far down the pipeline, and you know that they are going to be realized with some probability of success. And that acquisition of one of those pipeline projects is an issue. And that's been the area where innovation analysis has been quite successfully applied in the past. And I would think it would continue to be applied in the future in that area. So, I do think that there is an important application there.
Yeah, because innovation matters, right? I don't know, I got this title from...
I've heard about that. Yeah, I think I'd agree with that.
Can I add a word to that?
Of course, I was expecting... but don't worry, I have a couple of questions to create a good fight toward the end.
No, no fight.
No,
I think we need to reconsider whether there's any room for a potential competition doctrine once we've moved to the hypothetical monopolist test for market definition. Because remember, what the HMT does is it looks not only at the firms who are currently selling in a market, but all of those who could be selling in the market in response to a small but significant and non-transitory increase in price. That is firms that don't have a major irreversible entry obligation in order to get in. And so then the question is, once we've included these firms that are not currently in the market under the hypothetical monopolist test, is there still a group of potential competitors left out there that the HMT does not pick up? And for me, the answer is I don't know for sure, but I doubt it. And I don't think it would come up very often. And so if we're using the hypothetical monopolist test for market definition, we might just think about dropping the idea of going after potential competition mergers.
30 seconds.
Just, Herb, I don't think that would pick up the case of potential competition from something in clinical trials, where you can be pretty sure that there's a 40% probability that this product is going to make it through the clinical trials, but until then, it's not going to be in the market.
But you would count it as a potential competitor?
Yes, but not in an HHI calculation.
Okay.
So we reached the point where at least we have the kind of discussions that are on the substance very important and outside the realm of just a couple slogans. I want to move to you now, Gustavo, because CADE has been taking a unique position when it comes to vertical mergers in digital. Can you give us a sense of what this is and why you think you get it right?
Okay. Well, we very recently issued a guideline for vertical mergers. I'm not quite sure if CADE is very unique. What we tend to try to do is look at the market and the evidence. And we are trying to use a lot of empirical studies and economical studies. So in that point of view, I'm not quite sure if it's quite unique. At least there are a couple of jurisdictions that do that. I don't oppose to the idea of having some kind of simplification on the process, and sometimes you can use presumptions, but you use presumptions when it's something that you already have studied a lot of times. There is exam, a test that you have applied a lot of times, and you don't have evidence that's probably this test is going to be a different result. So just like cartel, we know for a long time, it's very hard that the cartel is going to be inefficient. So then we say it's per se, and that's it. With digital markets, the opposite, meaning we know so little about these markets. We have so many questions about how these markets are going to respond that these are the cases that we should not be using presumptions. These are the cases that we actually need to examine with more scrutiny because we know so little about that. Regarding, of course, there are some cases that's very difficult to implement ideas like input restriction, like price increase. Sometimes it's very hard to establish that. But regarding digital markets, I believe the view of CADE has been more relaxed than other jurisdictions. And the main reason for that is that we are not observing in these specific players a behavior that resembles a monopolist. When you look at big players that are monopolists in traditional market, there are some red flags that you observe. They tend to have less innovation. They tend to have higher margins. They sometimes are very oblivious for what's going on in the market. If you look at, for instance, digital photography, this kind of technology was implemented way before it was popularized. The major players did not use that. So usually monopolists are very reluctant with innovation. What we're seeing in the digital market is the opposite. If something is concerning the digital markets, so much innovation is coming up. Well, for me, it's very fast what's going on. I was just talking about AI, and we, of course, we had to stop during 6 months the development for AI. This is the symptom that the innovation is actually too fast. This is not something you would expect in a monopolist. And what we're seeing with the acquisitions of new companies is that innovation is actually coming from startups, just like Midjourney and OpenAI. And if you look companies like Netflix, there are companies that are coming from nowhere. And at some point, they receive an injection of money, of investors, and then they are these big giants. But these innovations are preceding them. So we are not looking at these markets like vertical integration mergers regarding digital platforms. We are not seeing the red flags that you would expect for monopolists. And that's why we are having a more cautious examination of them. It does not mean they are all innocent and never harmful. But to this point, we are very skeptical of interrupting that.
In other mergers, reading Jeff's question, suppose outside digital, your agency has been innovative in designing remedies. That's what he thinks. I have no idea. Could you explain that?
Well, I'm not sure if it's offensive or if it's a good thing. Well, usually it's very hard for CADE to block an operation. It's very unusual. We block a few. But we always try to do remedies and try to follow up on that. So this is why I believe that we have sometimes innovative remedies, and sometimes we just follow up the operation. And we just say to the place, look, we're going to examine that for a few years, and we can reverse that. So we always put this kind of threat. It's actually in our law that if the operation is not going the way we predicted, we can basically reverse that. It's very unlikely it actually happens, but it's like your mother watching you. Like, you're probably not going to do anything, but if your mother say, yeah, I'll keep an eye, you're probably going to behave. So a lot of remedies, basically, at the end of the day, are monitoring. Basically, we're monitoring what's going on after the merger, and if necessary, we're going to intervene. It's very hard that it actually happens, and we need further measures.
Okay, I have a question for anyone on the panel that would wish to answer this one. And I'm going to frame it in a way so that not too many of you will want to, in the interest of time. Let's assume that with the Trump administration, we see more M&As than before. And let's assume that the willingness to block mergers will go down. Would you have any suggestion as to what could be innovative remedies that could make sense in a digital context? Is there anything you'd like to propose that has never been tried or that is tried very rarely or maybe in a small jurisdiction? Please, Herb, go ahead.
Digital markets in particular, we need to pay more attention to whether the relationship between the parties is of competitors or of complements. Because so many large digital platform acquisitions of tiny firms are in fact acquisitions of complements. And there's always a chance that a complementary product producer can turn into a competitor somewhere down the line. But when a merger involves the acquisition of a complement, you're getting real short-term gains. I'm thinking now, a year ago, maybe 2 years ago, Google acquired Brizometer, which was an Israeli company that digitized weather data. And it enabled Google to add air quality search to its search engine. That's a good thing. That's not something we want to condemn, even though there is at least a technical possibility that Brizometer could eventually turn itself into a version of Google Maps or Google Search or something like that. So we need more respect for complementary relationships and for the immediate gains that they can produce.
All right, thanks a lot. Philip, you wanted to say something? No. Yes, go ahead, Paco, and then Richard.
More, I'm going to be very brief. But
very innovative.
Innovative, but in particular in Europe, once we have the DMA, isn't everything that you could think there in the rules? So everything would be forbidden. You know, Article 5 and 6, they forbid everything. What he was saying, this Google, if it buys this company, he couldn't do any kind of self-preferential or anything. So here, we won't have any more, innovation in terms of remedies. I mean, we need to go somewhere else.
Yeah. All right. Great. Richard?
So if we could promote interoperability, which isn't easy to do, but if you could do that, I think that could solve a lot of problems that might otherwise be the result of combinations that might be troublesome.
Then I have a follow-up question. Would you do it kind of in a Microsoft way, looking at the commission in which you say, okay, do it, and this is exactly how I want you to do it? Or would you do it more in a Google Shopping way where you say, well, please come up with something eventually and we have a look at whether we think it works?
It's not an easy thing to do, particularly if you can't get buy-in from those who would do it, because there are a lot of ways to impede interoperability. So you need to do it in a cooperative way.
Yeah, all right. Anyone else?
Well, you have you have the explanation of how you do interoperability in the answer that Apple has given to the Commission in implementing the DMA. I think the main rule is for Apple saying, okay, if you want interoperability for third-party players, just come and make a request, and I'll think about it.
Cool.
Just a quick jump back to Richard. I agree with a lot of the virtues of interoperability, but they require modularity of the underlying service. And if it's something like weather mapping, that's great because that's very modular. You know how you can fit it into the other things the company does. But if you think about, I was thinking about the merger that never happened between NVIDIA and ARM, which raised a lot of hackles and so on, in spite of the fact that I think in principle those things were complementary. There's nothing modularity about what ARM does. It's a complex, innovative group of people who have certain competences, who are not really able to tackle other things that ideally they ought to do. And the whole promise of the NVIDIA ARM acquisition, which never materialized, was that it would allow these complex ecosystems to kind of figure out a way of working together. You can't make that modular, and you can't make interoperability part of that. So I think I completely agree with Richard. That's a solution to some of these problems, but it won't work for all of them. And indeed, I think most of the most interesting ones have this sort of complex ecosystem, figure out how to work together problem rather than the air quality mapping.
Okay, we just killed another slogan. Interoperability is the solution. Okay, this one's down. Let's move on to part 3 of the discussion. This one is about the interplay between innovation on the one hand and concentration on the other. And I was, if I may say, the one idea that made me think the most is what we've heard today, that, well, actually the divide between big tech and large tech and small tech is not so relevant, because it may be that one will license the technology to the other and that they may actually finance the technology. So it may be that the divide is not that obvious that we want it to be. And so the question that I will have for you, Marc, is, given your findings and your already published articles on the subject, what would you suggest as a way for agencies to distinguish between productive and harmful concentration? And are we there already?
Harmful
and productive, or concentration that would lead to more innovation? Because indeed, as we've heard, prediction is hard, especially when it's about the future. So.
Well, I don't think that there have been too many things on that. The impact of innovation.
So let's then, I guess maybe what he had in mind is your work on killer acquisitions and the ability indeed to detect the kind of acquisitions that we do not want because they would harm.
Yeah, well, if we look at what we have done is to look at what this type of acquisition, how they can impact the competitor, for example. Okay, so indeed, first thing is whether the product has been continued or not discontinued. Okay, so apparently what we have seen is that there are no evidences that all the products have been disappeared. So what we observe from the literature is that when you have this type of acquisition, there is a transformation of the product, okay, but no disappearance. The second thing is you can always look at what happened to the competitor, whether they are still have market shares, whether their market share have increased or declined. Okay? So it will have been the merger will have been bad if, well, and it's very difficult to interpret, in fact, because. But what we have observed is that for all the mergers that we have seen, there was no evidence that the competitor have lost market share. But honestly, it doesn't mean that if we had observed that the market share have decreased, it will have been an indication that the merger would have been, in some sense, a killer acquisition. Because there are so many elements that can happen that is very difficult to control, given that the data that we have. So I don't know if I answer, but it's.
It's a tough one, obviously.
It's a tough question. So. The problem is the main problem we are facing is right now is to what we have observed is, in fact, mergers that were above the threshold, and so they were investigated. But what is below the threshold? And so the question is relate to know, and that is in fact not in the job of authorities. It's the job of more of our job to evaluate the impact of the effectiveness of competition policy, and so to look at what is the impact of merger that are below the threshold, and how we can evaluate that. And for the moment, there are not too many analyses.
And the question is whether or not antitrust can ever be effective, or if we are not assigning a much more importance to what it can achieve compared to what is feasible. And in fact, I should mention that your work on the subject co-authored with Nicolas has been mentioned by Daron Acemoglu. So that's what you mentioned, Nicolas, earlier today. And it seems that the underlying idea that antitrust is responsible for concentration or maybe for innovation is maybe something that we like to think could correspond to reality, but is a bit far-stretched. If I move to you, Paul, we've heard from von der Leyen, and I hear that similar concerns are appearing in the US, that we need in merger control to factor in the ability for companies to scale. Now, a lot of what we discussed together this morning is that, well, we may want to look at firms and not necessarily sectors because of the idea that paracetamol is pharmaceutical is important, therefore paracetamol is strategic. But still, it seems that in some industries, the ability to scale appears to be more important than in others. So what do we make of that?
Okay, that's a really tough question, and let me answer it by just telling you something I was thinking about a little bit earlier today, which was how much does antitrust really matter if we try to think about a completely new sector, which is AI, and we try to say, what can public policy do for AI? And the sort of the way I come at this is by thinking this is a new activity. Why should we be concerned? We should be concerned for two main reasons. One is the possibility of substantial negative externalities from the output. You know, it could be used in military uses and so forth. But the other thing we might be concerned about is the process, and we might think about where the bottlenecks will be. Now, if I try to list what are the most likely bottlenecks for AI production over the next decade, I run down a number of things. One is obviously sources of energy. It's incredibly energy intensive. So we're sort of thinking about whether it's going to take place in Dubai and places like that. Okay. The other one has to do with semiconductor production, but it's not so much do we have enough semiconductor plants, though that's important. I mean, these are things, big specific investments, et cetera, large scale economies, but much more that the really cutting edge applications of semiconductors require the sort of complex, rather abstract relational capital that firms like TSMC have built up with their customers, and not just the ability to stick up a plant in Arizona and churn out the physical stuff, okay? And now there's clearly some kind of bottleneck about that, but we have no idea really how, whether the short-term steep supply curves are going to turn into flatter supply curves in a 5 to 10 year horizon. You know, it may be that firms in Japan and elsewhere, who knows, maybe even in Arizona, are going to be able to replicate those forms of relational capital. We don't know.
Yeah.
Then there's the really big strategic issue about, you know, a lot of this stuff is concentrated in Taiwan. We have a lot of reasons to think that Taiwan is strategically vulnerable and so on. And a very long way down the list of these bottlenecks, I come to the possibility that maybe there'll be mergers between companies that will restrict the supply of AI. But I can't see a universe in which antitrust issues, you know, concerning who's going to buy whom, are really going to be first order in answering the question about the bottlenecks to the supply of AI.
Yeah.
But what I do fear is that antitrust authorities, responding to the sense that this is a big, scary topic and we have to do something, are going to be trying to carve out a territory in this space and to say, actually, yes, as antitrust agencies, we should be responsible for doing this, and to some extent inventing bottlenecks or the possibility of bottlenecks to justify their interventions. Now, that doesn't make of me a sort of let's not intervene at all, but it's saying that we need to have mechanisms as a society for prioritizing interventions according to the objective importance of the likely bottlenecks, rather than to the current configuration of the agencies that are clamoring to be allowed to do this. And when I think about what Commissioner Rivera is going to be charged to do by Commission President von der Leyen, I'm kind of afraid that what the Commission President is inviting the Commissioner to do is to say, please find some reasons to give us jurisdiction over this, rather than please find us some objective evidence for the supply bottlenecks. Yeah. And so I worry about the political economy of that process.
On that, and I will move now to part 4 of the conversation on industrial policy and antitrust. And the first question would be for you, Andy, because it links to what Paul just mentioned. Obviously, Taiwan's had quite a success when it comes to semiconductors. Now, as a competition agency, how do you consider the importance of TSMC in the economy? Is that impacting your competition analysis, your willingness to intervene? Are you in touch with them? How are you dealing with such a successful company?
Okay, thank you. Because Paul just mentioned TSMC, so I think I'm kind of obligated to say something about the IC industry. Yes, the TSMC is extremely important for the economy in Taiwan. Actually, as you can see, the TSMC impact on the stock market. Each time when there is a news about the TSMC future, the stock price drop or rises significantly. But from the perspective of the industry policy, probably I can say that the TSMC is the darling of the Taiwanese government, because the current policy is moving towards more likely encouraging the development of the IC industry rather than considering regulating the IC industry. But that being said, the TFTC has paid a very close attention to the potential competitive issues that might arise from the Taiwanese IC industry. We have conducted a very initial survey on the IC industry, and from the top to the bottom, the whole ecosystem of the industry. At least in Taiwan, other than the TSMC market, the upstream or downstream market actually are quite competitive, from the IC design to the downstream foundry. I think it's still very competitive. But
let me maybe be more specific. Are you in the mindset that if you see competition issues with TSMC, you would need to enforce the law because making it free of those anti-competitive practices is actually good for the company on the long run? Or do you sense that, well, maybe we should be careful with the company?
Oh, no, from the perspective of competition law, yes, we need to enforce the competition law. Of course, you can expect there might be a challenge or need to make some kind of cross-agency discussion regarding how the competition law should be applied to the very important industry. But I just want to emphasize that TSMC itself is very keenly aware of the potential competitive risk in the future, especially from international competition community. So recently, actually, TSMC championed the idea of broadening the concept of the IC industry. They have this slogan. They said there's an IC industry 2.0 version. They try to kind of enlarge the ecosystem to include not only TSMC, not only the chips, but the whole ecosystem should be expanded to include the upstream and downstream. And by doing that, I think they try to avoid the impression that TSMC is a monopolist. Because once the market has been enlarged, people will look at the broader picture instead of focusing on TSMC, on chips, on the R&D of the chip or the manufacture of the foundry of the ICLE. So I think strategically TSMC is moving toward that direction.
Yeah.
It's all on the news in Taiwan. So
and it seems to me that you are very aware of what the company is doing, the strategies, which also you know, is saying something. Reiko, now, I have to ask you the question when it comes to industrial policy and antitrust, because Japan has been engaging in industrial policy for quite some time. So I suppose that it must be quite exciting for you now that in Europe we are catching up and asking the question how to do industrial policy. What can we learn from you?
What not to do.
But what would that be then? Because that would be very interesting.
Oh, actually, Japan itself has learned, I think. Industrial policy was very, very important in the 60s, which is more traditional industrial policy in that it would concentrate, the government would support a particular firm, usually, to try to push it and make it into national champion, sometimes support an industry. That was the traditional industrial policy was what it used to do. And I think this time around, it understands that that doesn't work well, partly because the environment's changed, size of the Japanese economy's changed. Actually, what's industry that has been successful is, for instance, the automobile industry, which has been very, very competitive domestically. And that's how firms became very competitive globally. And I think the government's figured that out. And the way they're subsidizing they don't subsidize one firm in particular, but they would subsidize the industry. And they also learn, as I alluded to what the Draghi report was saying, that it includes everything from labor markets, building up human capital, making sure the financial markets work, for instance. So the industry policy has changed in Japan, I think, and I hope people will pay attention to that.
Is an industrial policy somehow, although I understand from your answer, maybe it was less important today than what used to be the case, but is it integrated within the antitrust analysis, or are you conducting antitrust analysis to which eventually you will confront industrial policies?
Actually, I think we've been helping. We figured out that we can help industrial policy work more efficiently. In the 60s, it was either industrial policy or enforcing competition law. But now, we help the labor markets work better. We've looked into how the IPO market worked, gave notices to big banks that seem to be in the way of startups being able to get good price for IPOs, for instance.
Yeah.
So it's more, we're integrated, I think.
All right, so good
Not
lessons
integrated,
indeed.
complementary.
Yeah. Please. I'll ask you to be, no, go ahead first, Gustavo, but I'll ask you to be very, very short.
I really find interesting the discussion regarding industrial policy because it has nothing to do with antitrust, first of all. Mm-hmm. We have learned so much about it on the wrong way, and it's quite interesting it's coming back. In Brazil, we had terrible experience with national champions. We have very strong data that proves us that these companies afterwards invest less, they are less prone to innovate. And there are these whole incentives are just capturing the government to keep the subsidies going on. So it's much better for the company just invest in stuff like corruption and lobby than actually invest in new technology. The good part of being Brazil is that we deal with BRICS, which means we discuss with China, Russia, and that kind of subject. One of the subjects was recently discussed is that shouldn't we allow cartels to work together so we can face the problems regarding COVID and regarding the war in Russia? And it really makes no sense, because if that was the case, if relaxing the enforcement on cartel was that positive, well, we should just retire and make the economy grow. And now we're going to have two problems. So my main concern is that we're walking into a world, because Of course, the rest of the world is not going to see industrial policy in Europe and just say, oh, that's good, and not do anything. We're walking into a world that's going to be more isolated and probably less efficient, because now all these chains that could be integrated somehow are going to be broken. So this is something that, I'm not saying that industrial policy is all bad. It could be done rightfully, but I don't think this is something that belongs to antitrust agencies.
Herb, again, I'll ask you to be short.
Very close to that position, I think, in the U.S. Within the neoclassical model that we follow in antitrust, it's not the job of the antitrust laws to pick champions or to establish industrial policy. However, if industrial policy were to be established legislatively by Congress, then antitrust law would have sort of the same obligation as it has with regulated industries, which is to figure out how to make antitrust work against that particular industrial policy framework.
Yeah, thank you very much. Okay, I'm going to move to part 5 of the conversation, which is going to be extremely short, because I'm just going to rely on one speaker, which gives a lot of importance to that speaker, and that is you, Philip.
For balance.
So whatever you say will be unchecked, and then we'll move to the room for questions. And you'll see that's a very small question that Jeff drafted for you. Critics may argue, we may have heard that the DMA is not so good for innovation. Would you share that view? And if not, what would you answer those people?
Yes, I think that generally speaking, an over-inclusive bit of legislation or an under-inclusive bit of legislation, which the DMA is both of, can have extraordinarily restrictive effects on markets. I'm a fan of pro-competitive ex-ante regulation generally, but like everyone in this room, I would say that evidence matters, economic theory matters, so does equality of opportunity to exercise choice. And I use those words very carefully. There's a very elegant paper written in 2014 by an inquiry chair at the Competition and Markets Authority called Philip Marsden, who talked about exercising choice in online markets. And he moved away from the debate in the US about choice and just talked about the exercise of choice. I'm not talking about number of competitors. I'm not talking about some sort of industrial policy design. I'm not talking about allowing less efficient competitors to come in. I'm not talking about abilities or anything like that. We're talking about the quality of opportunity to then show your wares and see if you win or lose on competition on the merits, which no judge anywhere has ever been able to define internationally, as an OECD study showed. But if there's going to be one thing that people should be focusing on is how are the authorities going to explain this? I think the DMA is too rigid. It's going to send all the cases off to Luxembourg. That's what we were trying to avoid. Hence, come across the channel. Okay. Have a talk with the CMA.
Let me ask the final question before I open the floor. In a couple years, we're going to gather again, and we've heard from all of the speakers that we need to be able to measure things. How do we measure whether the DMU and the UK approach is indeed better than the DMA? So that in 5 years from now, we can actually prove that you were right all along.
Okay, so I think when any competition is asked to justify their budget, they always come up with a figure that's about 10 to 13 to 1, right? We blocked this merger, saved billions. We allowed this merger, saved billions. So I think that kind of specious sort of addition by competition authorities is not helpful, and indeed unhelpful. But what we're going to see, I believe, if things are applied correctly, and I would say this, wouldn't I, having headed the UK's retail banking investigation, was when an interoperability remedy is correctly applied, you don't need to do breakups, you don't need to worry about concentration, you just need to be able to provide that equality of opportunity for the fintechs to access what's essentially an arbitrary standard, interoperability. Yes, it's difficult, but most of the time it's not that difficult. And what we saw and what we've measured in reviewing the banking provisions is that we've seen a flurry of fintech entry, right, that's not only related to VC funding, but it's related to being able to access the data sets of the big banks who weren't using their data sets anyway because they didn't feel any competitive threat. So I get very passionate about this, and people will say, oh, you're relying on the fact that you think small businesses are more innovative than big businesses. No, we're British, we want our cake and eat it too. We want the innovation from the big guys, and we want some space for the innovation from the little guys.
Yeah, so what you suggest is that you count the amount of breakups per jurisdiction, and the more, actually the worst jurisdiction probably proceeded. All right, let me now open the floor to
Two questions.
Very good and patient.
Two of them. We're going to do 2 questions.
So the
and
very,
then,
very best.
Yep, well, it looks like we found 2 questions. And if you have other questions, ask them over champagne. And we'll actually finish, because Yogi Berra, the baseball player, has come up twice today, with some additional slogans that maybe we can take moving forward. So we'll start here with our friend Oliver.
Yogi Berra also said you can observe a lot by watching. So when it comes to measuring the impact of enforcement, this might be one.
Exactly. Okay, I have a question and a comment. Is that all right? Yes. Okay, so they're both addressed to Paul. So first of all, the comment. You commented on me, so I feel I'm entitled to comment back. This idea that you now are safe with your Uber driver because of the app. It's very nice, and I think there are some examples like that undoubtedly, and technology can help here. But I would ask you, suppose you feel one of your colleagues isn't really being a very good colleague. Do you think an app is going to solve that? I rather doubt it. So I think for those kinds of things, you need more along the lines of what I was talking about.
Agreed.
My question is, when you referred to this, is it Hunt Alcott or Hunter Alcott? Yep. Okay, that paper. It looked kind of nice with all the, was it green and the consumer surplus. One of the things I'm wondering may be missing is political activities of firms. So firms lobby, they make political contributions. Think of ExxonMobil, which over the years has sponsored very questionable science, which minimized the seriousness of climate change, and these days lobbies against sensible climate regulation. Okay, that would seem to me ought to appear on that figure, and could be, I think it is extremely negative.
We agree.
Well, that was great. Thank you.
Hi, I'm Kay Jabelli. I work for Chamber of Progress. So part of the theme of today has been that or rather the implicit, if not explicit critique, is that authorities have been enforcing on the basis of slogans and less on empirics, which is leading to or will lead to bad results. And I'm curious if anyone would be willing to prefer some thoughts or predictions as to how will this play out. I know one of the first slides showed Andreas Schwab saying, for example, the DMA would lead to lower prices, more innovation, and more choice. But if that doesn't happen, what happens next? Thank you.
I guess it's make antitrust great again.
Good. MAGA, yeah.
Yeah.
Another way maybe, and that was my final question, we don't have the time, but I wanted to ask maybe for one or two of you, are you being positive about the future of antitrust, or are you more pessimistic as to the direction we're taking, which I suppose is another way of framing the question? Anyone on that?
I'm hugely positive because none of this digital regulation itself pollutes antitrust itself. Yes, it upsets the companies. Yes, it upsets all sorts of governments. Yes, it upsets the economic and legal experts, absolutely. But to quote Michelle Obama, it is what it is. We're there, and let's go on with the empirics if they're available and enforce the law in an explainable, transparent manner like that. But I don't think that antitrust itself is going to wither or change or become polluted. Far from it. We've given another outlet to a pressure.
And it makes for great conferences, and we cannot end the conference on someone else saying that you are on the negative and pessimist side. So I think now is the time to.
Perfect. Phil, get your clinker ready because we've got some new slogans coming up here from Yogi Berra. Of course, it's tough to make predictions, especially about the future. We found that applied today. Perfect. You can observe a lot just by watching. Thank you. It's deja vu all over again, which is helpful. And if you don't know where you're going, you'll end up someplace else. This is quite the philosopher. And I'll end, because we're in Paris, even Napoleon had his Watergate. Thank you, everyone, for coming. It was a pleasure to have you all here. Please join us for the reception downstairs.